Hello everyone and welcome back to the channel. My name is Sholya Chakraborty and I'm working as a legal intern at Lexis & Company. The topic for today's video is the trademark scuffle over COVID-19 vaccine Covishield. COVID-19 brought against the entire world a bunch of challenges for survival, leading to the closure of almost everything in the year 2020. The entire world was waiting for the vaccine to arrive so that life could restore its normalcy. The Serum Institute of India announced their vaccine Covishield and was approved by the Drug Controller General of India on 3rd of January 2021 for emergency purposes and restricted use. Covishield vaccine carries its name in the nature of its use. It protects from COVID and hence it was named Covishield. In December 2020, a company named Nandin Cutis Biotech opposed the vaccination name, stating that they were using the name for some of their products in the business. This forms the basis of disputes between the companies. The statement of law. A trademark is defined under Section 2 as any mark which is capable of being represented graphically and of distinguishing the goods or services of one person from another, and it may include the shape of goods, their packaging and combination of colors, and other things. Infringement of trademark occurs when the trademark is a copy of registered trademark with few additions or alterations, or if the infringed mark is printed or used in advertisements, or if the infringed mark is used in the course of trade, or if the mark is used so similar to the registered mark that is likely to create confusion in the minds of the consumer in a category of products. In the current case, both the companies have filed for the registration of the trademark and the decision is pending before the registry. There are principles that support the use of trademark in case of concurrent and honest use over the prior use of the mark. In this case, Cutis Biotech is using Covishield as a name for their product that is used for the purpose of protection from COVID-19. Similarly, the Serum Institute of India is using the name Covishield as a name for their vaccine that is used for the same product. Intricacies of the case. The Cutis Biotech has mentioned in their complaint that the registrar has opposed the trademark Covishield registration to the Serum Institute of India as it had been applied for registration before by the company itself. The Serum Institute of India did not respond to the objection and later in the year announced the launch of the vaccine. Cutis Biotech also claims that such an announcement, its dealers have stopped taking manufacturing orders for their product in the same name and is causing grave and urgent loss to the company. The company also states in the plain that the goodwill of the company is also affected by the mispresentation committed on part of the Serum Institute of India. Hence, they pray to the court to restrict the Serum Institute of India from using the trademark Covishield or any other similar trademark for the proposed vaccine, which will cause serious and irreparable loss to the company. Moving on to the analysis. It has been long stated in the case that the company Cutis Biotech has filed for registration in April 2020 and began using the mark in May 2020, whereas the Serum Institute of India has applied for registration in June 2020 and has been using the mark since then. Cutis Biotech and Serum Institute will both use the trademark Covishield for the purpose of protection from COVID, which is descriptive of the term. Hence, this trademark is descriptive in nature. A trademark is defined under the Act must be able to distinguish the product or services from that of the other. In this case, both the companies cannot get it trademarked unless they are able to prove that the use of the trademark is not descriptive in nature and that it enables the consumer to identify the product as that of Cutis Biotech or Serum Institute of India. The difficulty of proving that Covishield does not belong to its common meaning is itself an extremely challenging task. Hence, the burden of proof is a lot heavier on both the companies to prove that the mark Covishield has a different meaning that protecting from COVID to get the registration done. In case both the companies are able to prove the same, the terms of the law that state that the company should be able to prove the prior use of the mark, in which case the Cutis Biotech has applied for registration prior to that of the Serum Institute of India and has also been using the trademark prior to that of Serum Institute of India, and therefore it should be granted the benefit of prior use. As of now, the case is pending before the court and the results are awaited. Thank you. Please like, share and subscribe to the channel.